I want to turn over to my two colleagues. We're going to be doing our hypothetical, our ethical hypothetical Sandy homeowner, and we'll be having some fun with it today. But Sam Milkus is the Executive Director of Plan, our host for the whole conference, and Catherine Martin is the, say your title.
I'm not sure.
You have a title? You have something on your thing. But
I work for Neighborhood Legal Services.
But everybody in neighborhood has a title. Aren't you like director of something?
Yeah, sure.
Okay.
I think my credentials for being here, that I'm a member of the Allegheny County Bar Association Ethics Committee. So I'm one of those people who meets monthly and discusses the questions that people have called in about. And it's been a really interesting process, I think. It's because I think at Legal Services we would all agree that these ethical questions come up all the time. I mean, these are not academic questions. They're really everyday matters that we have to think about. And so it's been interesting for me to be on this committee and have sort of an intellectual approach to it. So I've really enjoyed that, and we are going to have our own intellectual analysis of the situation today.
And I'm so excited to be here because we're not going to do any work at all. You're going to do everything yourself. We're going to have you guys work through the hypothetical. It says a visit from Sandy homeowner, ethical challenges. And you'll notice that there are 6 questions at the bottom. You, as part of this exercise, are going to work in groups. And we're going to group you by parentheses. I don't know if you've ever done this. I'm a former 3rd grade teacher, so I apologize for these kind of things. When we group by parentheses, we take these 3 tables over there and we group you together. See by parentheses? Parentheses, you have to get it, you got it, you figured that out already. So that's a group, and you guys, because you're the first group we have, you're going to do question 1. Isn't that cool? All right, so the 3 tables there, and if you guys, the 2 front guys, if you wanted to move back and join them, make it easier. Otherwise, you guys can just turn around. The 2 tables here on that side, you're going to turn around and group, and you guys are hypo question 2. All right, the 2 tables there, you're grouped together, and guess what? You get question 6. All right, it's just because I get bored easily, so we had to choose that. But you can turn around. If you guys mind turning around, oh, you will mind turning around for some of your partners, but you have to do it. And you guys have question 5, okay, which gives you all kinds of excitement because there aren't that many questions left for you guys to do. And with 2 of you, turn around and join them, and just come with this in the table here, so that you guys are there. All right, and you guys have a choice. We only have 2 hypotheticals left. We have 3. And we have 4, so you've got a choice. Which one do you want? Think about it. And then, if you wouldn't mind, madam, we're going to have you come up and join this group. There's even a chair for you, we've saved. Okay? And if you guys had a decision, do you want 3 or 4? Question 3 or 4? Thank you. 4. So you guys have question 3. 1, 2, 6, 5, 4, 3. We're going to give you 11 minutes to figure this out.
15, I think.
I think 11 and a half at least.
Okay, all right.
So turn around, start reading, and get to work. We have other important things to talk about while you work.
But to be more precise,
yes,
you got to read this, and then each group needs to select a spokesperson who is going to describe for all of us what your assessment is of the question that you are dealing with.
And see, Sam has never taught 3rd grade because knowing the mindset of 3rd graders and people at a CLE section, he would have realized that if he'd said already that you're only going to pick 1 person, the groups are now going to point to that lady and say, you're doing it and you just do it and we'll all talk among ourselves. So you don't have to pick your person yet. Yes, sir.
I assume we're supposed to use this little...
The green book! Why do we have the green book? The line book. And why do we have it?
I assume that our answer is supposed to somehow cross-reference.
Do you guys know the Prego commercial? This is the ethical version of Prego. It's in here. Okay. It should be in here. It may be in here. But it's there. And those of you who are doing the ghostwriting question, you actually have a whole extra supplement to look to. So that won't really help you much at all. Okay? Are we set? Ladies and gentlemen, boys and girls, our first group is ready to present. I think as the first presenter, you should give us sort of a broad summary of the hypothetical, and then give us your question. And you are?
He's waiting to shake your hand.
Yes, I'm waiting to shake your hand and ask you to stand, kind sir. And introduce, this is Dan Sachs from Community Legal Service. Is it Dan? Dobie. Excuse me. All right. So a quick overview of the hypothetical for the group, and then we're going to jump into one. And we have our spokesperson for number 2 already. Do we have our spokesperson for number 3? Oh, there he is. For 4? Thank you, kind sir. 5?
5 needs somebody.
Yeah.
Going.
Well, you know, I only know Charles really well, so that might be the person in 6. And you know, with really good luck, if people talk more than 3 or 4 minutes, you might get past on 6. But Dovey, one thing we do know is that you're on. And the floor is yours, and there's cameras here for you.
I don't know why this happened, but I feel like it is the presenter for my group. So the summary of the hypothetical is that,
You just going to say?
yeah, Sandy.
Be comfortable.
Sandy is having a rough time with her mortgage. She's falling behind. Her relationship is a little bit on the outs, and they're pondering divorce. Comes to pro bono attorney, asks for help. Our issue deals with whether the lawyer can ethically assist this woman in maintaining the mortgage and keeping the house when she fears that she won't be able to afford even a possible modification or whatever workout that the lawyer can help her with. More largely, should I expand to the whole hypothetical? I wasn't really focused on this because number 1 didn't necessitate going beyond it, but it seems that the lawyer has a neighbor who is a housing counselor.
You don't have to be.
No.
We have other people who will be
great.
wonderful. They're waiting in the wings to do the rest.
Great.
But let's just deal with your issue on just this whole thing about what's the ethical issue here?
So the ethical issue, some people in our group thought that maybe there was an issue with there not being a meritorious claim, and therefore the lawyer could not ethically argue that this mortgage should be preserved because the client wouldn't be able to maintain it.
Is there anything in the book?
Yeah, there's something in the book.
3.1.
3.1.
Page 63.
Page 63.
And that's always the way to do it, is you say the rule and then say the page. It makes it so much easier for people.
Great. So the rule is that a lawyer shall not bring or defend a proceeding unless there's a basis in law, in fact, for doing so that is not frivolous, which includes a good faith argument for an extension, modification, or reversal of existing law.
And that sounds like something we're going to be dealing with in another question, but what just about, have you brought some sort of fraud against the court, against the tribunal, by her saying she thinks she can pay this mortgage and you know in your heart and heart she can't?
No. I think that probably haven't, because you haven't even filed anything in court or made any assertions. The mortgage is certainly not the law, it's maybe a contract. And I think we agreed that in the end you don't know what the outcome is going to be and what the terms of any modification might be. It may be cheaper than anticipated. So probably she could have.
And she could win the lottery.
Right. You win the lottery. Okay. Or the lender could be beneficent and just let her have the house. So you could probably ethically take that case and do what you could do. We thought maybe it would be important in the retainer to specify what the lawyer is going to do and that she was going to try to help versus ultimately secure an affordable modification. And that there probably wasn't an issue, but there would be an issue with who she's representing, just the wife or the couple as a whole. But I think that comes up a little bit.
That's going to come up in a little bit. There is the whole issue we always get into in representation, because the rules really don't talk about when the representation begins and how it does. And we always talk about with pro bono lawyers, I mean, obviously in legal aid as professionals, you understand the need for an agreement to make sure that everybody understands the rules and things. So I like that you have the representation agreement there. But what about just the general duty an attorney has, that we give good counsel, sound advice? Especially when we have limited resources, whether it's a legal aid person, a professional in the legal aid office, or it's a pro bono attorney or paralegal who's helping out. We have limited resources, and should we be utilizing resources for things that won't work? Do we have any duty to say, to do some piece? Your thoughts? We have an appellate panel, by the way, back here, that may give and have thoughts.
Yeah, no, I don't know about a duty. It's certainly good practice to consider those things. How many people are living in that home and will be affected by foreclosure? How unaffordable it seems to be. My experience is that it is pretty unpredictable as to what you can obtain. So I think in good faith you probably could take it. I mean, unless the numbers are just ridiculous. But definitely should consider that and other possible clients you might take in lieu of that one.
Okay, wonderful. Dobie, round of applause for Dobie. Thank you. You started us off. Sam, other things you want to add, Catherine?
Yeah, I'd just like to add on this that when you're talking about the retainer, which I think is an important part of this, and in Rule 1.2, you talk about limiting representation, when is that permissible, and there's a whole movement in the provision of legal representation of, they call it unbundling, and it's really a matter of limiting the service that you're providing, and they say that in the rules of professional conduct talk about, well, you can do that, but it's important that two things. The limitation has to be reasonable, and that depends on the type of case it is, and the client has to give informed consent. So when you're doing the retainer, I don't know if all of you have a solemn ceremony. Ours tend to be somewhat perfunctory, and we do explain things to clients, but you really need to, if you're putting a limitation down in that retainer and saying, I'm not going to court for you on this, I'll do negotiation, but I'm not litigating, or whatever you're doing, you need to make sure that you've explained that to the client and that they understand. Now, they don't have a lot of choice, probably, but you want them to know what you're going to do for them, and that's the basic reason behind the retainer. But there is, I think lawyers, as far as the rules of ethics go, have some discretion in what service they're going to provide, but you need to make sure everyone knows what's going on.
And the rule 1.2 is on page 8, and the rule is followed by the comments, and the comments obviously are extensive. For those of us who didn't have to actually study this really hard when we went to law school, it's always good to look at. Sam, anything else to add?
Not on this one, no.
Our chorus, anything to add? Which means, no? Nervous anticipation leading up to our expert for question 2.
Our question was whether there were ethical problems with representing both sides of an estranged marriage and foreclosure case when both sides are co-obligors. We thought that there could be issues with that, and we focused, I guess, on Rule 1.7.
Page 20?
Yeah, page 20. So it relates to a conflict of interest among current clients. Here there seems to be potential conflicts between representing the estranged husband and Sandy homeowner. Their goals might not be consistent. Husband's goal seems to be to drag out the process, at least for now. It's not clear what his ultimate goal is. Sandy homeowner's goal seems to be definitely to save the house. So if the lawyer is supposed to zealously represent his or her client, it's hard if it's not clear what the ultimate goal is, because there are two conflicting goals. Another issue here is that there might be some issues between husband and Sandy homeowner, because husband has been inflating income, I think, in some of the materials for the mortgage.
And we'll get to that.
Right, so that might cause another conflict between the two of them. So it seemed like sort of fraught with ethical problems.
Is there anything you can do?
I think it'd be helpful to speak with estranged husband and flesh out his position. That's one thing I would like to do.
Wonderful. And John Paul, right?
Yeah.
John Paul, thank you very much. Round of applause. Now, what do you think, Catherine?
I think those are good points to make. I think that this comes up a lot for me, and I've had cases where I've felt that I could continue to represent one of the spouses. Say if one decided they didn't want the house anymore and the other one did, but they were okay with the one who wanted it to keep on fighting, and then I just represented them. I've had cases where I've felt that I couldn't represent either one of them anymore. You hate to do that, there aren't that many other options for our clients. So, you know, I think, especially legal services, we do need to be very careful about abandoning people. Beth?
What about just representing Sandy alone in the first place?
Mm-hmm.
I mean, we didn't agree with Providence's take that she could only represent Sandy.
You know, let me just pick up on that, because I think that is a good fit for this situation. And there's a period of time when I was in private practice and I was doing divorces, and I would frequently have the husband and wife, maybe it was a relatively civil situation, the husband and wife would come into my office and they would say, we want you to represent both of us. We're in agreement. We want a divorce. Well, the fact is that they may not be on the same footing. They may not both have the same knowledge about the claim to a pension, or whether there might be something different than a 50-50 split depending upon marital misconduct. And whenever you get yourself in a situation, even when the people are saying, oh, we've got it all worked out, or we're in agreement, you really have potentially put yourself into that conflict. And the easy way to me to deal with it is you're just upfront with both of them and saying, I'm only going to be able to represent one of you. And you have to understand that person is my client. That's the person that I have my obligations to. It may be that the other of you chooses not to be represented, and that's fine. But you need to understand where my responsibilities are. When you look at the rules, clients can consent to a conflict of interest so long that the lawyer first has to determine that the lawyer feels like they can reasonably accomplish this with the consent of the client. I mean, if the lawyer feels like there is just too much of a conflict here, then consent doesn't get over that. But even the consent means it's an informed consent. You have an obligation to walk through with the clients the possibilities. It could be that we're in the middle of this divorce and we're in the middle of this foreclosure and you two decide to get divorced, and now I'm in a situation where I'm trying to advise both of you when you've got different interests. I mean, things like that have to be explained, in my view. So you've got Rule 1.7, which is talking about the conflict of interest and the possibility of consent. You've got Rule 1.8, which gets into some of the specific rules about conflict of interest. And you've got Rule 1.18, which is duties to prospective clients. And all of it, there's kind of repeating rules about the existence of this conflict. So to me, I think that's the reasonable way to try to deal with it. Ever trying to represent both a husband and wife in any legal proceeding when they're on the outs is a problem to me.
Hard enough when they're on the ins. So, yes, John.
So I have a substantive law question, and Beth was sort of explaining a little bit of this to me. What is the effect of the default judgment saying against husband on wife if she's defending the mortgage action?
If the mortgage action, the default judgment is going against both. It's going against both. There's co-signers.
Not if you...
The plaintiff would take a default judgment against
Oh,
one
I'm sorry.
party
I'm thinking.
if they didn't both answer.
Yeah.
Right.
So,
Then they couldn't schedule it for sale without
Right.
having a judgment against all the
Right.
parties.
Other than share sale, what are the consequences of the default judgment? I guess
Against one party?
They establish the debt or the obligation that one of the parties has.
I don't think it would have much effect if they just get it against one.
Yeah, if you get one, it shouldn't have any impact at all for a married couple.
Okay. I for some reason was thinking of marital obligations, debt incurred during marriage. Or something.
I mean, I've actually had that happen, I think twice, and we all just kind of pretended it hadn't happened. You know, it had no effect.
Perhaps our chorus has something to add.
I'll add. I feel like it's really important for us, augmenting what Kathy says. I think I'm more liberal about this. I believe it's really important for us as legal services attorneys, the last chance legal help that these clients are going to get, that we do our best to represent clients so long, even if a PFA action, and now there's a foreclosure case, and the defendant comes to us to ask to represent him in the foreclosure action. I don't see that. I think we should try to figure out if there's a conflict before we say, oh no, because we represent the other side of the PFA action. And I think that what Sam alluded to, that we can ask both sides if it's okay to represent. If they both agree that it's okay to represent the defendant now in the foreclosure action, there's no problem. And I just feel like it's, lots of this conflict of interest and turning clients away is really supposed to be covering our asses. And I think that we are too protective of ourselves to turn too many clients away.
Yeah. Eileen, I agree. I think attorneys need to know more about this, and then they will understand, I think, that there are fewer things that really constitute a conflict than people fear. And so I guess one of the ways that a program has to deal with it is to make sure you have a good process, so that if, everyone, I assume, is checking for conflicts when the initial eligibility determination is made, and then you have to decide, have a good process for what happens next. If a name shows up, you may not want that intake person making the decision as to whether that's a conflict or not. And so just have a set way of handling it so that someone becomes knowledgeable about these rules and makes the right call and is not too restrictive. Because I agree, I think when people make mistakes, they're erring on the side of denying service when they shouldn't.
On the other hand, and this often happens, is that most of our programs have such backlog that if you deny somebody because of the conflict, there's going to be somebody else that you can now represent. And so there are programs that take the opposite approach for that very reason, that we'll always have other clients we can help. And why get into a situation that may put our attorneys, our paralegals into a bad.
Well, then I would say they're not following the rules of professional conduct properly. I don't think that's the way you should make decisions about who you're handling and just say, oh, too bad for you. There's this potential conflict. I don't know. It just seems like that is not the way to make those decisions.
Right. Well, our Greek chorus has come through with a little word from the wilderness. That is good. And we're going to move to question 3. And Randall, I believe you have the floor.
Okay, our group dealt with question 3 regarding inaccurate information on the application. I don't know about you guys, but every time I see this book, the print gets smaller. I get older and it's harder and harder to read, but I'll try to do my best here. We looked at this issue as a question of disclosure and confidentiality, which is basically 1.6. And the basic rule is that you would not disclose information the client told you in confidence. There's 2 exceptions, one being the mandatory disclosure and the other is the permissive disclosure. The way we looked at it under 1.6c, the permissive disclosure is only if the information must be could be disclosed to prevent reasonably certain death or substantial bodily harm, and we didn't feel that was applicable here unless something's going on between the husband and the wife and the woman. But not likely that that's going to apply. There's a mandatory disclosure that applies under Rule 3.3 on page 64, which basically talks about candidates towards the tribunal, and that says that the lawyer represents the client in an adjudicative proceeding and who knows that the person intends to engage or is engaging criminal activity related to the proceeding, then that is a mandatory disclosure that the lawyer has to do. Okay. Apparently, any inaccuracy here was in the application, which is in the past. I don't think there's anything in the hypothetical that says that the client's going to continue to engage in any sort of fraudulent activity, so I don't think that that's a requirement as well. The hypothetical also says that the husband puffed the information. We don't know any details as to whether he straight lied, or he just sort of said, well, maybe I'm getting more sales commissions than I'm hopefully going to get. So it's not too clear what the issue is, but under these circumstances, we would not disclose any of this information. Now, the other issue had to do with if, in fact, there's going to be continuing fraudulent in the future, then there would be a duty to disclose. But the problem is that that's not likely to occur here because the if it's a modification or some disclosure, the lender is going to ask him, well, what's your current income? And he'll have to say, well, I'm unemployed or whatever it is, I don't have an income. So any modification can be based on the current situation, not the past. So it would also apply in the situation of modification. Now, if in the proceeding itself, under a court or under a trial, the question is, can the client lie about whether he made an application falsely? Obviously, it would counsel him to, answer the questions accurately. If the counsel says, was this your income at the time? He'll have to say, no, I didn't reflect it accurately. So you've got to counsel your client to ask or to answer the questions honestly. And finally, the group had a sort of a discussion under Rule 1.16, whether they should either decline or terminate representation based on withdrawal, based on the client persisting in a course of action involving the lawyer's services that the lawyer reasonably believes is criminal or fraudulent. And again, there's no indication in the hypothetical that the client is intending to engage in this. And it's difficult to see how he could continue to engage in fraudulent behavior in a loan modification because it's based on his loan. So that's how we analyze this.
And that sounds really good. Let's see if the chorus has anything they want to add.
We affirm.
Randall, round of applause. Wonderful. And in keeping with the fact that we gave you a supplement on ghostwriting, and I would be so afraid, and Charles would be so afraid that we would not get to question 6 in its full depth. We're going to jump to our wonderful expert for Group 6. And Brenda, if you wouldn't mind, the floor is yours.
Okay. Our question was whether helping pro se clients by ghostwriting court papers presented an ethical problem. And it turns out that the answer is crystal clear, it's maybe. This handout was very helpful, and it discusses the issues like whether ghostwriting is misleading the court, whether it gives a procedural advantage to a pro se litigant, whether there is an invasion of the attorney responsibility when one is ghostwriting. If I could bring everyone's attention to the conclusion paragraph of this handout.
Page 7.
That's right. The ABA position is, the trend in the ABA position is to permit ghostwriting, and there have also been endorsements of ghostwriting in ethical opinions, but it points out that, and other state jurisdictions permit ghostwriting, but that attorneys should still be concerned about the practice of ghostwriting. And then, of course, because it was so clear, we came up with some other questions too that were raised, like whether ghostwriting a frivolous pleading would be appropriate, because that would be inappropriate for an attorney to do, but could you help a pro se litigant do that? And whether malpractice issues would still apply. And then also that there's a broad range of what is ghostwriting, and it's one thing to maybe provide a pro se form or some instructions, and then an entirely different thing to actually prepare a document and have a pro se litigant submit it with their name.
Brenda, excellent. Round of applause for Brenda. Kathy, I think there's some things you want to add.
Yeah, I think that is good. There's a real spectrum of what might be considered, and you just have to think about it. What's appropriate under the circumstances? Are you confusing the client? Do they think you're going to be handling this because you're kind of half in? You just need to be aware of these issues, and the fact that the ABA has clearly come out and said they're all in favor of ghostwriting, that does not, in my opinion, resolve the the problem for us in Pennsylvania under our rules of professional conduct. Pennsylvania has not taken any position that's in accord yet with the ABA, so we have to be careful. Hopefully, and Legal Services has certainly been moving in the direction trying to expand service by sort of giving a little more pro se assistance than we used to, and so it's just, I just wanted us to talk about the issue because I think this comes up all the time. I am encouraged by the fact that the ABA has taken the position it's taken, and that's clearly the trend things are going. But you got to watch out. You know, you're the one going to be talking to the disciplinary board, so you got to be careful about what you're doing.
And I just would add, David and I were at a session in Philadelphia a year or so ago, and we were talking about this issue, and Judge Messiah Jackson was there as part of a panel. And she made the comment in that session that if she sees a self-represented litigant come in with a pleading that really appears as though a lawyer has had a hand in writing it, she will ask that litigant who the lawyer was, and she'll get that lawyer on the phone, and she'll call them in to get involved in the case. So there is this distinction, as Kathy suggests, between actually drafting a pleading and then sort of letting a self-represented litigant take that as though it was their own, versus assisting people with their own completion of forms. You know, for example, the Protection from Abuse Act actually requires certain levels of assistance to self-represented litigants in being able to file their own protection from abuse petitions. You actually have a statutory mechanism for helping people, and that's a line that I draw is, to what extent are you actually just helping a self-represented litigant with their litigation, and to what extent are you actually doing the work and then letting them sort of use themselves as the front for the work? That's where I think you get into the trouble with candor to the tribunal.
Yeah, and judges have varying opinions, and
Yeah.
unfortunately they're not going to be the one making the determination of your disciplinary complaint. So we've had a judge in one of our counties said, oh, they noticed all these credit card cases coming through and that have been aided by our office, and the judge said sort of, I see this and it's fine with me. And then this other judge is saying, no, they don't like it. They want that lawyer in there. So it's an unresolved question.
And to emphasize how unresolved it is, the PBA, if you're a PBA member, you can actually call the PBA or email the PBA. Victoria White is our attorney who staffs our ethics committee. And you can, if you have any question, if you're a PBA member, you can raise it with the committee and they'll deal with it. If you aren't a PBA member, you can email me and I'll get it for you and email it back to you discreetly on the side. But we just had a committee meeting where we spent the entire meeting discussing this issue and decided to table it. That it did not come up with a response yet. And it is, I think, your local practice really where it is important. If you have judges who are going to call you up, I'd be very, very careful about my ghostwriting. I'd probably be very clear in my discussion with the person I'm ghostwriting for what are the limits of my ghostwriting. It's still a representation, it really is, and it still probably brings you into all kinds of malpractice and other issues. The other thing to just stress on this, though, is that as we get more and more technologically sophisticated, and I hope all of you have been looking and using both of the websites that we work with Plan on, the PA Law Help and the PA Pro Bono.net, but the PA Law Help already has some hot docs which people can fill in their own information, and it prints out a document that you would say to the judge, nobody help me, I just got it off the computer. My feeling is that you're pretty safe if what you're really doing is being a manual hot docs for somebody in an area of law that we don't have a hot doc up for. Where we do have hot docs up, I think you're much better off just from a resource standpoint, directing people to those questions, to those tools. And as we see down the road, I think that's the direction we're going in the self-help area, to being more and more automated. So you'll see this. And that's why I think this question is such a good one for now. We're trying to figure out ways to do so much with so less. Does the chorus have a comment?
I have a question to you. I don't understand why you would find that distinction, because if you have a defense, if you use hot docs to fill in the blanks for a predatory loan foreclosure case, the client might very well be able to answer the questions, the factual questions, but they're not gonna know anything about what they just did or what it means. So I differ with you on that distinction.
Okay, I'm not sure which of my distinctions you
You said that
differ.
you don't think that that's unethical, that that's.
No, if you're helping them fill in the forms, I don't think, if it ever comes down the road that ghostwriting is unethical, helping somebody fill in a form, I don't think is unethical, but I think what you've said is exactly right. To use most of the forms, people will need knowledge. And we do clinics now, we do self-help clinics where we educate people. And literally what I do in my self-help clinics is I say to people that for the moment you're walking in until the clinic is done, just assume that I'm your attorney. Because most people do assume I'm their attorney if I'm talking to them. I call about 6,000 people a year, people who have gone through and not found help. And we just try to get them in some direction. And on every one of those calls, if you ask them, many of them call me back and go, I want to talk to my attorney. And I remind them that, I'm their attorney for the limited purpose of this conversation. It begins if they agree, and it will end when we hang up. And the same thing on these clinics. I think that's probably the direction. If we get an actual opinion, I think you'll see more and more that what you have to do, because we have allowed for limited representation. A decade ago, you didn't have the limited representation option. It's a much easier way to protect yourself today. I will represent you for this limited purpose of helping you fill out that form, and that's it. I think that's reasonable, and helping them explain what to do with it, I think that makes. What a good idea. I don't think I'll ever have a course again. No, you're wonderful. Sam, do we have time for?
Well, we have about 3 minutes left here.
Oh. So the question is, do we leave the 2 questions unanswered, or would you guys just like to give real quick answers? And I know there'll be horrible disappointment from spokespersons in the back.
Well, I'm going to we already have talked a little bit about pursuing a claim that doesn't have merit anyway. So I'm just going to add a little bit more to that. Clearly, a lawyer has an obligation to pursue claims with a certain amount of diligence, and diligence is set forth in Rule 1.3. So the lawyer should pursue a client's claims, and the question is whether whether there is actually some kind of misrepresentation, inaccuracy, misleading conduct, and then you get into the candor to the tribunal problem. And so to me, that's where the line is drawn. It can't be for the sole purpose of delay, but if there is a colorable claim to be made, even if a lawyer feels that it may be a losing claim, and actually the notes to these rules speak about that. A lawyer doesn't have to think that the claim will win in order to assert the claim. That is a reasonable avenue to take. When I prepare for these sessions, I oftentimes learn something just by reviewing the rules. I had in my mind that somewhere in the rules was an obligation to zealously represent people within the bounds of the law. And then I did this word search, and I'm realizing that you only find the word zealous anymore in the preamble to the rules. There isn't actually an ethical rule that says we're supposed to do anything zealously. But I still would like to think,
stay away.
I'd like to think still that we pursue people zealously, and if we can make a colorable claim, that we ought to be pursuing.
Okay, and our last question, do you want to just take a quick?
Well, this was the one about sharing information with a housing counselor. I guess what I've found is more than in this thing where the lawyer is thinking, oh, I'll give this to a housing counselor, it's usually the other way around. The housing counselors are calling and saying, tell me what happened with that case. And I'll say, nope, I'm not going to tell you unless you have a release. So that's, I think lawyers are pretty aware of the fact that they're not supposed to be divulging information, and they're supposed to keep the confidentiality.
We had this issue pop up this summer with the Get Help Now PA program that the governor and the first lady pushed with the PBA, because they wanted to do some follow-up financial information and counseling and things that would have required lawyers who would counsel clients to give information without that approval. And we basically just went in and, Sam, I think it was you went in and added that we had to get the client's approval to do that for the statistics.
Yeah, but lawyers do need to be aware of that it works both ways. And when I hear lawyers yapping in elevators and saying things that they shouldn't be saying, so that's always sort of horrifying to me. And when we have students every summer, I say, this information is not for your sort of entertainment. You shouldn't be identifying your clients. Nobody should even know that's your client unless your client says it's okay. So you shouldn't be just calling a housing counselor and giving identifiable details without your client's permission.
But as a hypothetical,
Yeah.
then sure, nothing wrong with it.
Right.
This concluded the ethics session. You all have forms that you have to fill out. You've been doing that all day, so you know what to do. Thank you all very much, and thanks to our panel.